Congressman Mark Reckless to ask the second urgent question. Mark Reckless.
Will the Cabinet Secretary make a statement on future tolling of the Severn crossings?
Clywyd, our position is that tolling should stop immediately the crossings revert to public ownership, given the barrier that they represent to the Welsh economy and jobs and growth.
I'd like to ask why the government in Wales isn't doing anything about that position. The Silk Commission said there'd be close coordination between the two governments on the future of the Severn crossings. St David's Day Agreement said the UK government would work with the Welsh government to determine the long-term future of the Severn crossings. And the DfT's own road investment strategy rightly recognises that the UK government only has the right to recoup its own costs from the construction, maintenance and management of the bridges, and only until 2027. It went on to say that, therefore, the DfT would work with the Welsh Assembly to examine the future of the crossings in detail. We passed unanimously on my motion on the 16th of November that the tolls should be abolished following their return to public ownership. The Cabinet Secretary wrote to me on the 12th of December, and the First Minister copied and pasted a section of that to his letter to the DPO on the 9th of January, saying a trunk road charging scheme under Section 167 of the Transport Act 2000 in relation to the Severn bridges themselves could therefore be made by the Secretary of State in his capacity as the traffic authority for the bridges, notwithstanding that they are not wholly in England. Does the Cabinet Secretary now recognise that that's not the UK's legal position and that they are seeking only to charge for the half of the Severn Bridge that is in England? And will he consider that what he wrote to me about the transfer order of 1999 has actually been superseded by Section 122 of the Local Transport Act 2008, which is inserted into the Government Wales Act under Schedule 5 on the devolved matters, Matter 10.1, the making, operation and enforcement of schemes for imposing charges in respect of the use of Welsh trunk roads. Whoever is the Highways Authority, is it not the case that half of that Severn Bridge and the tolling plaza is in Wales, and that provision gives the power to his government and this Assembly to make those decisions, not to the UK government? Is that not why they're only charging for half the road? And how does he suppose they can use the tolling plaza in Wales when primary legislation specifies the operation and enforcement of such schemes using toll rails in Wales, and that is in Wales, is a matter for the Welsh government? Will he also consider the Severn Bridges Act are very, very clear in primary legislation that the UK Secretary of State may only charge a toll until a certain sum has been raised, which UK ministers stated were approximately £80 million, and with the reduced toll would be raised by the end of 2019. After that, the continuation of tolling is unlawful on that primary legislation. Does he really think the UK government should be allowed to get away with using secondary legislation and order to continue tolling when that tolling is prohibited by primary legislation under the Severn Bridges Act? Given what we have done in this Assembly, does he understand that renaming a toll, charging a toll and calling it a charging order is not going to convince the courts? The effect is the same. It is to make people pay to cross the bridge, and that what the UK government is proposing is, in my view, unlawful, and certainly there is a strong arguable case that it's unlawful. And therefore, may I ask him that in order to give some effect to what he states his government's position is, and the unanimous decision of this Assembly on the 16th of November, will he meet with me and his lawyers to explore these issues in more detail? If he accepts that there is at least uncertainty as to the position, will he instruct a QC to give definitive external advice to the Welsh Government on this matter? And if that advice is that there is at least an arguable case that the UK government is acting unlawfully, will he take that forward, challenge the UK government if it doesn't rescind, to ensure that our rights here in Wales and the law are respected?
Can I thank the member for his question? I am sorry that the member has failed to observe our position, which I think has been very consistent. We have persistently opposed the existing of tolls when the crossings revert back to public ownership, and we have made our position very clear to the Department for Transport at both the ministerial and official level, and repeatedly in the media. I would be happy to meet with the member to discuss what I think is a very complicated and complex area of legal work, and I would also be happy to provide members with a comprehensive briefing of the various acts that the member refers to. I think he raises a number of important points, but principally we have a legal argument versus an economic argument, essentially. We have a legal argument that's being proposed by the UK government. We have an economic argument that clearly shows that removing the tolls would be beneficial to the economy of Wales. Now, I'm also disappointed, I have to say, that the UK government is not considering writing off the debt, which stands at something in the region of £36 million, given the UK government wrote off the debt for the Humber crossing, and it's my view that what's good for the Humber should be good for the Severn. And I'm baffled, I have to say, by the rationale that's being given, especially as the Severn crossings are strategic routes and not part of local authority networks as the Humber crossing is. It's my view that the Welsh taxpayer, and indeed other taxpayers, have already paid off that debt through considerable sums in general taxation over many years. Now, we were not given any advance notice of the consultation. However, I have written to express my disappointment at this, and I would be more than happy to provide members through a written statement my response to the consultation. The member raises a number of points concerning the Severn Bridges Act, and as he alludes to, it's our understanding, based on the advice, the legal advice that I've received, that the UK government is proposing to continue tolling by virtue of a road charging scheme, as the member mentions, under Section 167 of the Transport Act 2000. Whilst we don't think there's any reason to consider that this is not legally possible, I am more than happy to discuss this with the member, with lawyers. And indeed, I revert back to the point that I made earlier. Regardless of the legal merits of the UK government's position, I think it is entirely unjustifiable to maintain a position of taxing businesses and of taxing commuters across the Severn.